Hi, everyone. Thank you for joining us today as we explore changing data privacy regulations that will go into effect next month under the General Data Protection Regulation, or GDPR. My name is Daryn Nakhuda, and I am the founder and CEO of Mighty AI. Today, we are joined by two attorneys, Claudia Rast and Jennifer Dukarski from the law firm Butzel Long. Claudia brings more than 25 years of legal experience in cybersecurity and privacy, and Jennifer's practice focuses on legal issues arising from emerging and disruptive innovation, which includes vehicle safety and autonomous cars. Claudia and Jennifer will talk about the coming regulations under GDPR, how it will impact companies developing technologies for autonomous vehicles, and what you need to know now. We're happy to take your questions throughout the webinar and answer them in real time, so please send us your questions throughout the presentation by using the Q&A button at the top left of your screen. We'll also have time at the end for additional Q&A, so there's plenty of time to send your questions through. And with that, I'd like to pass it off to Claudia and Jennifer.
Greetings. Hello, and my name is Claudia Rast,
and I'm Jennifer Dukarski. Thank you so much for joining us today.
We are here to talk about GDPR and the coming deadline, the new global D-Day for business. As our title suggests, we are here to talk about what GDPR means, what it does, and what you need to know. And in sum, what you can do now if you haven't done these kinds of things already. So, moving into what does it mean? GDPR is broadly applicable, as this slide suggests, and it's not like it's something that's new within the EU. It has a history, but it applies to the processing of personal data in the context of activities of a controller or a processor. And it applies to the processing of personal data of data subjects who are in the union. And I focus on the in the union because it doesn't talk about being a resident of the EU or a citizen of the EU. It talks about individuals who are in the EU. The other thing that you should keep in mind with the GDPR is that it's tagged or applicable when you offer goods or services. It doesn't mean that you have to pay for the goods and services for your data subject to have applicability. It's the offering of those goods and services. And it also is applicable in the monitoring of behavior. And Jen, that presents an interesting situation for those in the autonomous vehicle area and the monitoring of behavior, huh?
Absolutely. As we move through the different phases of autonomy, and particularly at the lower levels of autonomy where we're making sure people are actually paying attention and able to resume control of the vehicle during what we would call a disengagement event where the driver takes control, that monitoring is something that's happening more and more frequent with technology. And this is true not just for autonomous vehicles, but for safety features in ADAS systems in vehicles around the globe today. And Claudia, that really brings me to a question. You talk about its broad applicability, and you mentioned that the GDPR has a past.
It does have a past. And interestingly, it all started back in the 70s with West Germany and their data protection laws and privacy, concerns about privacy. At the post-World War II and post, and actually then current in East Germany, Stasi issues. And the German law then was protecting privacy, which ultimately gave rise to the safe harbor response to the Data Protection Directive. So the Data Protection Directive was established in '95. It gave a safe harbor to U.S. companies, and that was in force for a number of years. Then Edward Snowden arose. That was stricken in a lawsuit, and then gave rise to the Privacy Shield. So it does have a past. It's been around, many of the provisions have been around for a long time, but they are reflective now in this GDPR. And when we say the harmonization may be global, it has an interesting kind of impact. And Jen, maybe you can talk about this, because in the automotive context, you're not picking and choosing your countries when you have AI in vehicles, huh?
Well, from the perspective of your customer base, it's quite easy to see that anyone supplying this technology is going to be supplying to a customer who would likely have a footprint globally. You'll have customers who may be from South Korea, but have plants in the U.S. in the EU, and really, I mean, it's anyone who thinks the automotive industry is truly regional, it hasn't been in the industry terribly long. It is a global industry. All anyone has to do is shuffle through your business cards and take a look at some of the addresses of either your contacts or of their companies.
Yeah, and so part of that, and we mentioned controller and processor and data subject and so forth, there's some key terminology that is useful, and we'll talk a little bit about that now. Personal data, we all kind of get that. That's it's often called personally identifiable data. Some of it can be sensitive, some of it can be just sort of your name and address, and it varies from state to state in the U.S. But it's much more broadly defined within the GDPR. We'll talk about consent, the controllers being the country or the companies rather that basically control the data. So they are the ones that will reach out. They will tell the processors, this is what I want. The processors do the processing of the data, and the controllers really are connecting the data subjects or the individuals to the processors. And we'll also talk about data breaches, which can be fun. So personal data. And again, this is broadly defined. There are some instances in some states that make personal data rather specific. But here we're talking about any kind of attribute that can be identifiable to an individual, and it can be a religion. I think one of the first instances back in the 90s was a menu selected on an airplane was a kosher meal, and that was considered to be personal data. And how is this personal data in the context of the AI going to play out?
Well, I think from the standpoint of the technology, you're finding a significant increase in, number one, a desire to monetize data collected by vehicles. And when we think of vehicles, we think of global vehicles. So any technology that's present in a car, connected, driverless, or otherwise, that can be turned into something that can be monetized, whether it's biometric data, which we're seeing an increase in, or other types of information that may lead to new channels of mobility. Imagine kind of the Uber or Lyft lifestyle replacing traditional ownership models. More and more data is going to be collected by those vehicles that will include name, address, and much like in this slide, perhaps even the brain functions of a driver.
Right, and just because it may be pseudonymized does not mean that you don't need the consent to gather that data. And we'll talk a little bit about the legal bases in collecting data in context. And the special categories of data, which is unique in this AI space, given the sensitive nature of the data that's collected, because it's biometric in many instances. And we'll talk about how that data as a special category has certain kinds of attributes. And consent, we're all used to consent typically in privacy policies, and we've heard about this, but in the GDPR, it's a little different in that this is not a matter of you have to opt out of something that we're used to in the U.S. And consent models, but the consent is got to be freely given and unambiguous and informed. And in some instances, it has to be even explicit.
So Claudia, if I get into a taxi that might happen to be an autonomous taxi in the EU, are you telling me then that I'd have to give consent and it would have to be freely given at that point in time?
Well, that's an interesting situation because you have various legal bases for that consent. And one could argue that by entering the vehicle, you have implicit consent for the data that may be collected for that ride, because you could refuse to enter the vehicle.
Well, that is true. That is true. I surely would definitely think twice if I'm being filmed and it's capturing all sorts of biometric data on me as to whether I'd hop into a driver or driverless Uber overseas.
What may also be there is the typical ubiquitous, soon-to-be ubiquitous screen in the back seat that says,
please click here.
Please click here if you want certain information gathered. Other important definitions that we talked about generally: the controller, the processor, again the data subject, and a personal data breach. The interesting thing with the data breach here, which some people are certainly noticing with some fear and trepidation, is the requirement under the GDPR is notification to the supervisory authority within 72 hours.
That's a lot faster than we're used to here.
It's a lot faster than what we're used to here, given the 30 days, 45 days, and in some instances, statutes in the states will say a reasonable time period given the need for investigation. Sometimes you don't even know if you have a breach from a forensic standpoint. So this is going to be and present an interesting situation. So putting this all together, this is a logic diagram that we've put together, indicating questions and assembling the definitions that we talked about. So whether you offer goods and services or monitor behavior, if that's a no, the question would be, is a controller within the EU? If that's a no, is the processor in the EU? If that's a no, GDPR is not applicable. If the controller or the EU, if the controller or the processor is in the EU, then the GDPR applies. And if you offer goods and services to data subjects, and that's a yes, the GDPR applies. So there are any number of ways that the GDPR can apply.
So let's give maybe an example or two. When we're talking about if you're a controller within EU operations, what would be a classic example of who a controller would be with EU operations?
Well, the interesting, you mentioned, I sat on a plane from Munich to London last month next to the fellow who was head of GDPR for BMW. There's a controller in the EU, and the GDPR he had been working on for the last 2.5 years. Very much aware of what needs to be done. Automobile companies in the EU, very much the controllers. In some instances, they're also the processors, but in many other instances, they have vendors for processing the data they're collecting.
So processing the data, that would leave you in that far right processor bucket.
Mm-hmm.
And would that apply even if you were processing the data in the United States on individuals in the EU?
Sure. Well, if the BMW entity had a processor in the US, absolutely. And if the US company had a US processor, but the data subjects were in the EU, what do you think?
I imagine so.
Uh-huh. So, you know, the thing to notice here in the bottom, the fines for where the GDPR is applicable and where we have the typical head in the sand, or you don't have a lawful basis for collecting that information. 4% of the total prior year revenue, or 20 million euros. That can be hefty.
Is it a which one's bigger or which one's smaller?
The greater. So what else does it do? These are some of the key changes which, if some of you are familiar with what already exists in the prior EU directives, 3 things stand out as being quite different and more expansive. One, the territoriality, the fact that it can apply globally is huge. And people will say, well, how are they going to enforce it? How are they going to reach me in Oshkosh? You know, if I have a GDPR non-compliance issue. And I'm guessing that eventually they will. But
well, the rumors and innuendos that I've heard through the circles is that shortly after this applies, they're going to find somebody who is within that increased territorial scope and make an example of them.
Poster children for GDPR.
Exactly.
And those penalties, again, will be and can be large. And the consent is different under the GDPR as well, because as I mentioned before, the requiring of a lawful basis, that's going to be important. And I think if you look at the various, we have 6 bases for processing data. The first 2 folks probably are familiar with. For this audience, probably the legal obligation, the public task, the vital interests are not necessarily applicable, but the consent, the contract, and the potential legitimate interest will be generally applicable. Consent being most common, contract being another one that's common. And the interesting thing about contract is it doesn't necessarily mean a written contract. You know, you don't have to have the person signing the contract when they enter that driverless Uber in the EU.
So your discussion about me entering the Uber suggests that a contract has been formed by me hailing that driverless car, or
an implicit contract.
An implicit contract.
And similarly, in terms of marketing, and I've had these conversations with companies that market within the EU and have U.S. operations. And they say, well, what if we're going to a networking situation and someone gives us a business card? Do we have to give them a contract to send them our newsletter? And the answer is no. There's an implied contract when you give over your information that there's an expectation. And so as long as you stay within that purpose, and we'll talk about the core privacy principles, you have that contract.
Well, here's an interesting question, and I think we'll get into this a little bit later, but you know, you're mentioning those people who are collecting business cards, and if you are issuing white papers, as many of our organizations do, especially those who are working on advanced technology and trying to push out content so everyone understands you know, what your technology is. What about all that data that we've collected over the last few years?
That's presently safe. You don't have to retroactively get consent for what you collected in the past, but you sure as shooting better not use it for a different purpose than you originally collected it.
So if I originally collected it under contract, we have to keep up with that contract basis.
Yeah, and you raise an interesting point, Jen, because you can't change your purpose midstream, nor can you change your legal basis midstream. So if you find that you originally collected it with a consent, and you say, no, I think I want to go back and say it was a legitimate purpose, you can't do that. That original consent basis, or that original lawful basis, rather, has to be consistent throughout. So that's going to be a tough one for folks to wrap their brains around.
So if I collected it to send white papers and to provide information for my customer base on emerging technology, I want to stay in those swim lanes.
That's right. Not only the purpose, but also the original legal basis.
Well, and that's really consistent with the notion of the core privacy principles, right?
Yeah, and that gets into what you need to know, and the privacy principles. And there are 6 core privacy principles that have been around for a long time. These have been contained within the EU Privacy Directive from 1995. Some of them have bases that goes back even further than that. Fair and transparent, that, you know, makes a whole lot of sense. Legitimate and explicit, you know, we have no reason to say that there's nothing difficult with that one. Adequate and limited. This is going to be interesting in terms of AI collection, because AI means big data, right? That's where you try to collect everything, create an algorithm, and make some sense about what it is going forward.
Find useful nuggets out of a mass quantity of data.
Right. So how does data minimization deal with AI and big data? What do you think? How are we going to do that? That's a little bit of a shoehorn. It's an interesting dilemma, and something that I think, you know, we'll see as we move forward. Obviously, in some of the AI, we'll talk about a legitimate interest, because you can make the argument that safety in a vehicle is reliant on the collection of the data, and the purpose being outweighing the risk of using that personal data, particularly when it's been pseudonymized.
And I can definitely see that, and we'll talk about it as we come to a close. That's very consistent with where a lot of industry standards organizations are going.
Mm-hmm. The other thing, of course, is accurate and current. But going back to adequate and limited, you know, again, it's got to be limited to what is necessary. So you can't, outside of the AI context, you can't collect more information than you need. And time limited. You can't keep it any longer than is necessary. So how do you have this AI that basically forms the basis of your safety components in these vehicles and say, okay, we can't use that information anymore.
Well, let's just hypothetically take a driverless vehicle where you are doing testing and you're creating, you're adding miles and you are monitoring individuals who are, paying attention. I mean, I always love to use the notion of the disengagement as kind of that classic link to take us from, some of the early levels of autonomy to fully autonomous. If we still have vehicles where you have to reassume control, there's a lot of monitoring going on to figure out the optimal way to re-alert a prospective driver that they have to take the wheel. So from that standpoint, if we've done historical testing with engineers, if we're doing that testing now, are you telling me, I think you're asking whether 10 years from now, that data set is still a valid data set?
Well, and upon the shoulders rest the geniuses of the future. So, that data will be building. It's always going to be, you're not one and done. You're not collecting and then stopping. This is all going to be used. But I think the argument can be made in this context that the time limitation for AI in this area is going to be very difficult to basically say, okay.
And there may be some useful life to some of the data that's collected, but at the same time, if there's extraneous data that's collected that truly has no purpose,
yeah,
I think that's the intention of this privacy principle, is to not collect more than you need and don't keep anything you don't need for an eternity.
Right, and IT people will appreciate the fact that they don't have to find places for storage for more data than they need. I mean, it's really a tidy component. Another is the secure and protected component of the privacy principles, and that, of course, is something that we're all used to in terms of encryption as we deal with things like HIPAA and health information. One of the issues that gave rise to the Privacy Shield and ultimately the GDPR was the EU's focus on what we in the West don't do to protect our data and don't have in the way of any kind of federal privacy laws. We have a mixed bag of 50 states now and some territories with different privacy laws. But having this information pseudonymized is important, and encrypted is important. And that's where you see some technology companies moving into the encryption space. We were talking about the CAN bus and ECUs and so forth.
So I guess this takes us from the core privacy principles to the notion of what the person hopping into the driverless Uber, or what the person who is testing the vehicle and being watched and monitored, what their interests are. And I think that's where we shift to the 8 rights of individuals. And I know from a perspective of the individual, wearing that hat, the right to be informed is important, to understand when data is being collected on them and what's happening to that data. It goes back and reflects on the transparency, Claudia, that you talked about a minute ago. Further, there's a notion that not only should this data be collected and stored someplace, but you as an individual should have some level of access to your data.
Yeah, and that's an interesting thing, because data portability, you're not going to say, okay, I want my pseudonymized data back that you used to form the logarithms of your AI. The data portability actually only applies to data that's been collected by consent or with contract. So it's not going to apply to legitimate interest, because.
But that's still complex. If you have
sure.
a test engineer who, again, you're monitoring and watching them, and you're collecting biometric data, you may be collecting their heart rate, you may be collecting facial features, you might be watching their iris, and you're doing so under an employment contract. If that employee leaves the company and says, I want a copy of all of the hours that I logged in, are you telling me that's what portability means?
Well, it was. Let me tell you what it was intended to do. The intent behind it was to sort of level a playing field for those controllers that operate in the EU, and that if an individual, a data subject, an individual in the union, wanted to move that information from one company to another, he or she would have the right to do that. Now, the interesting thing there is, what does that say about what, secret sauce that one company put on that information? And then do you carry those trade secrets or that secret sauce in machine readable form? That individual has the right to his or her information in machine readable form to a competitor.
So is that something you can address in your contract when you agree with people on what you're collecting and how it can be transported?
Well, I mean, the individual has a absolute right to the data portability and consent or contract.
They can get the data, but
they
can't get it with, they can't get the secret sauce behind it once it's processed.
No, they can't, but you're still talking about how one competitor or one company may feel about that data portability as it goes to another potential competitor. I mean, you're basically making it very easy for your customers to move across platforms.
Well, now that's frightening, and if you move over to the next slide on some of the other rights, right to rectification and accuracy. So there's the right of an individual to correct their information, but more interestingly, there's the right of erasure.
Yeah.
So if you do have someone with whom you've had an agreement to collect their data, but now they want to be forgotten,
mm-hmm.
that data set has to be able to be plucked out of the system.
That's right, and that's where it's very difficult in terms of what companies have to do to track the data. I mean, it's all a matter of accountability is huge. Documentation is huge, and that's going to be a big barrier because if someone wants to be able to be forgotten or to have their information erased, you have to know where to find it. You have to get to it, and there is some feasibility built into that. So if it's completely infeasible, you can, basically say so. Doesn't mean the person doesn't have the right to ask.
So at this stage in the game, that means we should be cautious on how we collect it, know how we can collect it, but at the same time not be overly concerned that they're going to grill us to the absolute minutia.
Right.
So looking at some of these other rights, then we have the right to restrict processing and data portability. I think we've kind of heavily covered those over the last couple of minutes.
Right.
So if we go on to the next, you have the right to object and the right regarding automated decision-making and profiling.
Yeah, now profiling is interesting, and this is largely in the context of monitoring behavior. There's a pass for agencies dealing with criminal behavior, criminal profiling, but profiling by itself is considered to be a very dicey kind of situation in terms of privacy, which is it's different than using the data in an AI context, because in the profiling context, you're dealing with individuals. In the AI context, you're gathering big data for a platform for the data to be used in that kind of context.
So looking at what we just came through, we're going to shift to best practices, and I know that we definitely have talked about a few things that come to my mind very quickly, knowing that when we're processing data, the ability to get our hands on it quickly and kind of characterize and categorize what we have is probably going to be important. But let's start with the don'ts.
Yeah, so this is not a made-up photo. This is actually a statute. It's in Iceland. And we don't want anyone to appear that way after a GDPR's deadline comes and goes. It's not a good look. Do not ignore the GDPR. If you haven't looked at it already, there are still some things that can be done, although I would say that most companies have been working on this for the last couple of years. There are basic assumptions that do not work in terms of thinking that it does not apply. So if you're just monitoring user behavior, you're not offering goods and services. Sorry, if you're monitoring behavior in the GDPR, for individuals in the GDPR, it does apply. Assuming that pseudonymized data is not personal data, it can be. because it's not, you haven't pseudonymized the data before you got it. It happens when you pseudonymize the data, when you receive it and process it.
So that raw data can be just as problematic.
Absolutely. And this thing that you're just the processor. You've only been contracted by the controller, and you didn't find the data subjects. Sorry.
You can't hide behind your controller.
You cannot. And so, and I've had these conversations and have been dealing with contracts since last fall between data processors and controllers, and how they indemnify one another, and how they make representations about what they do with one another. So contractually, there are things to do to protect yourself.
Let's talk about those do's then.
Yeah, so know what you are. Are you a controller or a processor? That's a starting point. Take a look at your privacy policies. It's pretty easy to be able to take a look at your existing policies and compare them with what is appropriate and applicable under the GDPR. And there are lots of examples in the Union if you take a look at EU kind of privacy policies. Really important is looking at that lawful basis. What information do you collect, from whom, and under what lawful basis? And you need to know if you need a data protection officer. The interesting thing about data protection officers is that if they are doing their duties, you cannot dismiss them. They cannot be fired if they are only doing what they are obligated to do under the GDPR. And not all companies require data protection officers. And we have a question. Is that what we have a question here? If a company is recording video data in an autonomous vehicle in public areas, does the company need to blur the face of those pedestrians in the recorded videos, even if that has an effect on the purpose of recording the video data?
Well, let's look at that from two perspectives. I think number one, Claudia, I'll let you answer from the data collection and GDPR perspective, and then I'll pivot and kind of talk about some of the rights of privacy and publicity that exist.
Well, from the GDPR perspective, that individual's personal data is being collected, and so without consent, and those photographs, there was a video image would be obscured. In terms of that context and the reason for that video recording, you want to know that it's a human being. You need not know who it is.
So in that case, that would not exactly anonymize, it would pseudonymize by using the blur out.
Prior to the collection, yeah.
Prior to the collection. So as you're recording it, how would you do that?
That's for the technology people to figure out.
So from an overall privacy perspective, let's turn to just the general notions of privacy law, particularly within the EU, and the same is true to some degree here in the US. Just generally capturing people's images without consent is indeed often very problematic. And for example, if you did so just in the state of New York here in the US and used it for a commercial purpose, that's actually at least a misdemeanor. So I would say blurring people who are not truly ones that you're collecting, and finding technology that de-identifies upon saving is probably something well worth consideration.
Yeah, and back to the GDPR application, there could be a post-collection blurring, but immediate deletion of
the original.
The original, yeah. I mean, there are ways to do that. So it's you try to protect the privacy as best you can.
And the same would likely be compliant under general privacy and rights of publicity laws.
And then in addition to the DPO, the Data Protection Officer, reviewing your internal data breach procedures and detection, again, because you're dealing with potential 72-hour notification. Now the time of the breach is not the time to figure out how you're going to have an incident response plan. Make sure, and that's just good hygiene, good cybersecurity hygiene. And documentation, we talked about accountability, and one of the things that GDPR requires, and many are not paying a whole lot of attention to, is the documentation proving each step has been done correctly. And so this is something that a lot of IT departments don't really do now, but to have a documented basis for that collection, and the information that needs to be given to the individual prior to consent. They have to know what their rights are, and you have to be able to document that you gave them their rights. So those are all important processes to go through.
So before we shift on to some examples, and I think that's useful timing, tell me if you think I'm wrong. I think an excellent place for anyone who's grappling with this to start would almost be to go to a whiteboard or a big piece of paper and understand where am I, to identify my role, figure out, am I collecting data? Where is it coming from? What am I dealing with? What does my technology do?
And who are your vendors?
And who are my vendors and who are my customers?
Yeah.
I think you have to go both up and down.
Right. I mean, and some people will say, and this is typical small web companies, they'll say, well, I'm not collecting any information from individuals in the EU. Do you offer that? Is this a mobile app that individuals can track their interests or tastes? Is it available in the EU? If someone wants to buy something, do you have shipping capability to send it to the EU? I mean, all those kinds of questions need to be addressed.
Big whiteboard or big roll drawing paper.
Yeah, and here we have some examples. Just reaching out to your contacts. This is a recent example of a notice from a law firm saying, we'd like to stay in touch. April 2018, let us know. And I give my approval. So you reach out that way. Here's one from Airbnb, not the same kind of thing, and also giving links to the new policies and procedures. Simple kinds of ways to do that. And frankly, it's an interesting way from a marketing standpoint of reaching out and getting new customer lists, having a way to contact your customers and clients. So that has some benefit there. We talked a little bit about the DPO, and this slide kind of addresses that and the point that I made earlier that they may not be dismissed or penalized. So we all should be DPOs, right? Just doing our work. It's not required for certain things, but it is required for public authorities and those. And this is why I put this slide in here in this context, because carrying out large-scale processing of special categories of data. And what are we doing with AI?
Large-scale processing of special categories of data.
So DPO, yeah.
And talking about that large quantity of truly specialized data,
yeah.
Just framing it from the perspective of where we are in the industry. And I made mention to some of these things earlier, but when you take a look at what you have right now, the car is definitely becoming the repository of data. We've got geolocation data, we have biometric data. You have a good example of Waymo and Tesla trying to beat each other out by who's collecting more data and information on everything from infrastructure features to the actions and behaviors of drivers and passengers. I think as I've attended CES over the last few years, both Claudia and I have observed that there's been a major shift in collection of this type of data. We're seeing more and more biometric data every year. And I think we were both impressed by the car that wants to connect with you and share its feelings. I think it was the Toyota Concept I.
Yeah. But the interesting thing on the Tesla and the Waymo situation is Tesla's using their drivers. That's how they're collecting their data. Waymo is, collecting it in
the raw form.
In the raw form, yeah.
So those have really unique privacy and security impacts. I mean, biometric data, even within the US, not thinking about the EU, there are now 3 states that have biometric data laws that are specific just to the collection of biometric data. There are 16 different states that have provisions in their data breach laws that are specific to biometric data. So, I mean, we really can't kind of ignore this. And especially with the test vehicles and the future possibilities of cross-border driving and the impact that GDPR will have on us, it's really changing the way that our system is set up. And how does this play out? Just one slide to be lawyerly for you. In the U.S., it plays out right now to where most cases dealing with your collection of your data from a vehicle are dismissed. It's not actionable. But the problem is more and more consumers know that their data is there, that their data may be vulnerable, and are going to continue to push the limits of holding companies, the automakers and the suppliers accountable for data issues. And this, again, is in the U.S., but it's very true globally.
Well, and the point to be made there in terms of actionability or not is California has proposed legislation in which there will be statutory damages.
And California is looking to mirror GDPR, right. Correct? Yeah. So really, I think, number one, don't think we're going to stay out of this if we're here in the U.S., even if you're only collecting information in the U.S. Watch for the portability of the GDPR and be careful, because I think things are changing, and really that's what this slide's telling us. So getting out ahead of things, organizations like IEEE, SAE, and others have jumped into this area, and IEEE's ethically aligned design, their principles for engineering these types of AI systems have captured so many of the themes that we talked about earlier in the webinar. The objectives are to protect personal data rights, access control, to create an accountability for framework, for transparency. What they're looking to do is to make sure that you're applying your local regional jurisdiction while understanding the digital persona, who it is that's actually having their data collected, the ability to control that data, transparency and access, symmetry and consent. I mean, the words transparency, consent, control, these things are everywhere. In a nutshell, IEEE version 2 has now been released. You see the cover for version 1 there. They are truly aligned with the concepts and notions of the GDPR as they're encouraging engineers to do their work. Looking at what Germany did ahead of time before, with respect to their ethics commission on automated driving in June 2017, these again are the things that they flagged out of the 20 items: transparency, education on the bases. I mean, this is literally the verbiage in the report, talking about the legal bases for data processing and collection. They really wrapped in the notions of GDPR, data sovereignty, and the employing of privacy by design. When you think about it from the perspective of companies who are going to be dealing with GDPR, a lot of people will talk about it like it's merely a business function, that's something that our business people and our IT people need to take into consideration. But as a recovering engineer, I beg to differ. It's not limited. It is important for engineers to understand the perspective of GDPR in truly designing their systems to make the ease of collection, the ease of ceasing collection, and the ability to categorize the data in methods that will make life much easier if you have to go back and perform the erasure.
Right.
You know, it's something that really needs to be understood at all levels of the organization.
You know, and it's important perspective to think that if this can be accomplished, if we can have privacy and security by design as we go forward with the connected autonomous vehicle world and scheme, that obviously is a much better situation, and we can only look by the current example of the internet, which was never intended as it was originally formed to be what it has become. And if it had been formed with privacy and security by design incorporated into the internet, we would not have nearly the situation that we have today. And we see a question here. How will a GDPR breach implicated on a non-European entity? And would DPO impose fine on an international entity under what country law? So if you've got a GDPR breach on a non-European entity, say you've got a data subject in the EU, and so GDPR applies, you have to do a 72-hour notification to the supervisory authority in the EU. If you do not do that, you are subject to potential fines and penalties and the supervisory authority will be notifying you. Now, the interesting thing is there are private rights of action in the GDPR. So individuals can sue, and many of the initial actions people think will be coming from individuals.
So if the individual, let's take it this way then, Claudia. So if the individual is in Germany and the entity, the processor or controller, is a U.S. entity, where are they going to sue, and how is that going to happen?
They'll sue in the EU, where they have the jurisdiction and where the supervisory authority has jurisdiction.
Now the problem for the American company is they availed themselves of that individual. They're either selling, monitoring, offering for sale. They've done something to touch the EU. Mm-hmm. So if you're dealing with an individual's data in the EU, you have consented to the EU's jurisdiction, correct?
That's right. Yeah, and I had a conversation with a privacy security colleague in Munich last month, and we were talking about how this will be enforced and what will happen. And he said, it's anybody's guess because of the jurisdictional issues and the reach. But if you want to be a global player, you're going to have to abide by global rules, and we'll all see how this plays out.
In other words, wait for that sample. It's coming. Somebody's going to get the poster child, who is a mid to large size, probably American entity, mm-hmm. playing in some technology space.
Yeah, to fund the supervisory authority with the initial 20 million euros, which will go a long way to fund the administration. So we have another question. I think, let's see, I was looking at the prior question to see whether we had answered all the aspects of that question.
I think we have.
And I was going to take a look here. Would a DPO impose fine on international entity? Well, the DPO is going to be the individual that works within the company that would be subject to enforcement action, and in terms of which country law, it would be the GDPR, which is a
European Union
law. Yeah. So I think we're certainly done with our part of the presentation, and to the extent that others have any questions, jump right in, folks. Thank you for your time. Appreciate that, and always enjoy talking about connected autonomous vehicles and GDPR.
Great. Thanks, Claudia and Jennifer. That was great. We have a few questions that came in throughout the presentation that you'd love to get answers to. And as a reminder to those of you on the webinar, if you can send additional questions right now using the Q&A button at the top left of your screen. So the first question that came in was, what do you think will be the most challenging part of compliance?
Ooh. Yeah, well, I addressed that a little bit in terms of the accountability, the documentation part, and also the data portability. I think the data portability will not apply in the AI space, but it will apply in other contexts, and that's going to be a challenge for IT people because they're going to have to maintain the information in a machine-readable form. And respond when individuals want to move from one entity to another. And again, with that's the documentation issue that's going to come up that's going to make that difficult.
Great.
Jen, do you have any additional thoughts on that?
Yeah, I think from a standpoint of this type of technology, I mean, you're right, Claudia, the risk of maybe a test engineer coming back and saying, delete my rides, may be relatively minimal, but as we go into a more launch phase where there's actually the technology out there commercialized, I think that the erasure and right to be forgotten aspect will indeed actually increase as time goes by. So I think finding a good design solution early on to be able to segregate that data is going to be the biggest challenge.
Great. I think this next question is a related question, which is really, how do I think about the right processes, putting the right processes in place for different scenarios? So right now I have test vehicles gathering data on European roads. Maybe in the future I have production vehicles, or I have vehicles in other parts of the world that are going into the same data store, going to solve the same algorithm. So how can I best ensure that my data collection process is compliant?
But it reminds me of what we all went through in the middle 90s, data mapping. When we had these exercises, everybody was trying to become efficient, right, Jen?
Yeah.
We did the Six Sigma thing.
Yeah.
Um, and the best way to do that is storyboard what you do, know where your moving parts are, and drill down and understand each component, and have someone on tap that understands the GDPR and where that will touch that moving part. That'll all be part of the documentation. It's a good exercise. There are folks lots of vendors out there that are in this space, some newly in the space, some that have been there for a long time. But the data mapping component and then tying that into GDPR compliance will be a really important exercise.
Yeah, I mean, I think that's it in a nutshell, and it's finding engineers who have enough fluency to understand, to understand fully what elements are being collected in the data, and particularly as some of the test information is clearly going to be much less personally identifying. If you're just dealing with, for example, black box data on speed changes, to the certain changes to the technology, just parameters that the vehicle itself is experiencing, there's a weaker link to a person than, for example, if you are collecting and watching a person for their driving attentiveness, if you were doing just a simple ADAS system, for example. So understanding what data has the biggest risk, the more biometric, the more personally identifiable, prioritizing those things, which probably in a test situation is riskier data than just, say, geolocation data, speed data, torque data, etc.
Yeah, I mean, I think the important thing is understanding that anything that you collect on an individual human being is basically going to be personal data. There's nothing that you're going to be collecting that you can say, well, this is not personal data if it's relevant to an individual human being, if it goes to part of that person's identity or who they are.
Yeah, and at the same time, knowing that if you're collecting, geolocation of infrastructure, it may be different than if you're collecting that retinal scan.
Yep.
Great. I think that's super helpful. And so we have time for one more question. So this one's kind of specific. It's what is a data protection impact assessment and when is it necessary?
Yeah, well, so the data protection impact assessment is required when there's a collection of sensitive data and there's a high risk involved. And
so that goes back to the biometric data we're talking about. So if you are out there and you are collecting anything that would be, physical health, the iris scans, facial recognition type activities, this is where you need to start paying attention and be prepared.
Yeah, and what is a high risk? And the guidelines go back actually to prior to the GDPR, and they've been around for a while, but they say that there are 10 criteria identifying what is high risk, and you only have to meet 2 of those 10 to fall within the grasp of high risk, and thus a data protection impact assessment.
Generous of them.
Generous of them, yes. And just, any kind of data transfers outside the EU. So if you're collecting this sensitive information and it goes outside the EU, the presumption is, of course, that the EU knows best on how to protect.
And if you're exporting it to a U.S. tech center.
There you are. Another one is data processed on a large scale. So hello, those are 2 criteria.
I think we, for the most part, have triggered many of them. So with those criteria, Claudia, what do you need to do in this type of an assessment?
Well, it's going back to the data mapping, all right? So you have to figure out what you do, how you do it, how you protect it, how you store it, everything else.
So it's the whiteboard concept or the big roll drawing and putting together a plan on how it's tracked.
Yeah, and we have another question, and this goes back to what we talked about earlier in terms of who is a data subject and how are they defined. And again, the regulation itself says an data subject in the union. It makes no reference to having been born there, how long they might have lived there, whether they are an actual citizen, resident. It could be Jennifer Dukarski, who is in London before
Brexit,
or in Munich,
Yep.
having her data collected. She is in the union,
If they're
and the
collecting,
union is protecting its data subjects.
I'm happy to know that they will protect my Starbucks order when I'm overseas.
There you are. Well, Daryn, it's been a pleasure participating in this webinar this afternoon. If there are other questions, we'd be happy to answer them offline, or if you gather them and want to send them to us. But certainly,
Well,
we've enjoyed this.
Great. Well, thank you so much, Claudia and Jennifer. And thanks to everybody who joined us for your time today.